All right, guys, buckle up, because we're diving straight into courtroom chaos, where confidence meets reality head-on. From the very start, you can feel the tension brewing as this Florida defendant walks in with the bold decision to go solo. No lawyer, no safety net. The judge wastes no time setting the tone, calm but firm, making it clear this isn't going to be some casual back and forth. What we're witnessing here isn't just an arraignment. It's the opening act of a slow-motion legal disaster.
All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir.
All right, guys. Now things start getting serious. The judge lays out the charges one by one, and they're not light. Drug possession, fleeing police, driving offenses. It stacks up fast. You can almost hear the weight of 30 years hanging in the air. But surprisingly, it doesn't seem to shake the defendant at all. That's the first red flag. When someone hears decades behind bars and still insists on going alone, you know this isn't going to follow a normal script.
You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in Florida Department of Corrections and a $10,000 fine. Count 4 is driving while licensed, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
All right, guys, here comes the moment where reality should kick in, but it doesn't. The judge clearly explains the consequences, practically offering a lifeline by reminding him of his right to a lawyer. But instead of reconsidering, the defendant doubles down. It's like watching someone ignore a storm warning while sailing straight into it. The confidence might look strong on the surface, but underneath, it's starting to look dangerously misplaced.
Sir.
Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
All right, guys. Now the judge begins the formal process to confirm whether this man is even capable of representing himself. Education level, mental state, employment, it's all being checked. On paper, everything seems just enough to pass. But there's a subtle tension here. The judge isn't convinced, and you can tell he's already anticipating trouble. This isn't just procedure. It's the court quietly bracing for what's coming next.
Assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file some motions on the record as well, sir.
All right, I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and enter your plea.
I ended up pleading not guilty.
Okay. All right, you're filing motions.
Yes, sir. I
You
got
have copies.
All right, guys, this is where the judge lays down the reality of self-representation. He explains the legal system isn't a game. You're expected to know procedures, evidence rules, everything. And most importantly, the court will not help you. That's a massive warning. And yet the defendant responds with confidence like he fully understands. But understanding something and handling it in practice are two very different things. And that gap is about to show.
got declaratory judgment, and I want to furnish this bond to the clerk.
You file it. Go ahead.
For my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now, you providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about.
All right, guys, we move into the plea phase, and things still seem somewhat controlled. The defendant enters a not guilty plea, standard move, but then immediately tries to shift gears by bringing up motions. This is where things start to wobble. It's like someone trying to play chess after only learning how the pieces move. You see effort, but also the early signs of confusion creeping into the process.
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that, and if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
All right, guys, now we hit the turning point. The defendant starts talking about bonds and documents that clearly don't fit the legal framework here. The judge steps in quickly, correcting him and emphasizing procedure, copies to the state, proper filings. This is where the courtroom dynamic changes. The judge is no longer just guiding. He's starting to control the situation tightly, sensing things slipping out of bounds.
To do that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date.
All right, guys, and here it is. The moment things fully derail. The defendant starts referencing obscure legal concepts and obligations that have no place in this courtroom. The judge shuts it down instantly. No patience, no tolerance. This is the clash between internet legal myths and actual law, and it's not even close. The authority in the room becomes crystal clear, and the experiment of self-representation is hanging by a thread.